people will come in. Good afternoon, everyone, and a warm welcome to our third workshop on the Personal Data Protection Act proposed the passing of the Act earlier this year. This is a series of workshops that we've been hosting from the Ceylon Chamber Academy in partnership with Meta and of course support from ICTA to roll these workshops out. The first two were held quite successfully. The first one being quite a general one where we did an overview of the salient features of the Act, brought in a lot of global resources as well to kind of give a regional and global flavor to or context to the Act as well. And the second one, which we held on covering the information and technology communication services sector. So today's one is really another sector focused one, which we will be focusing on the financial services sector. And indeed, we're privileged to have a great resource for this session as well. It'll be in two parts, and we'll have the first session featuring Dr. Aritha Vikramanayaka and Pavitri Vitanage from the central bank, together with Sandhani, who will be the moderator for the entire workshop as well, taking place. And then after that, in the second session, we'll have Jayanta Fernando and Kanchana from Central Bank, as well as Cheryl Pal from MasterCard joining in as well. So thank you to all of our resource personnel for accepting our invitation and being part of it. And I think this will be a continuous dialogue that we will be having, because I think in the 18 months or so that you have from the passing of the Act to the setting up of the body and the implementation, there is a lot of gaps that need to be kind of looked at, the role of the private sector, impact on different sectors, which we hope the workshop will hope to kind of identify and cover as well. And indeed a pleasure to also continue to collaborate with Jayanta and his team, who are part of the drafting team, to understand the implications at each sector as well. And the feedback and learnings and input from each sector, I think, is helping us to design future ones as well. And I think the next session we hope to have will be a physical one. It will be a general coverage once again of the Act. So it will be held towards in November, the first or second weeks of November is where we're looking at. And then a few more sectoral workshops, mainly focusing on the health and insurance sector, to name one that is in store at the moment. So we thank everyone, the ICTA, Meta, for their support. And without taking too much of time, let me wish the... Thank you.
Thank you, Shiraz. And thank you for the introductions and giving the overview of what we have done so far in this workshop series. So today I'm joined by a very eminent, two very eminent panelists, Ms. Pavitri Vitanage, from who's the Deputy Director at the Legal Department of the Central Bank of Sri Lanka, and Dr. Aritha Vikramanayaka, who is the President Partner at Heritage Partners. And so just to contextualize the discussion for the next 1.5 hours, so the theme of this panel discussion is the impact of the Personal Data Protection Act and the intersection of sectoral regulations in the context of personal data processing in the banking and finance business sector. So we hope to explore with our two panelists the intersection of the provisions of the newly enacted Personal Data Protection Act, also known as the PDPA, and its intersection with sectoral regulations that are stemming from the Banking Act, as well as the finance business laws, and how prepared, or what are the things that the industry needs to look at when it comes to complying with the PDPA, especially when there is a overlap of, in certain respect, an overlap of sectoral regulations when it comes to personal data processing. So far, I think one of the reasons why the PDPA was enacted in the first place was to address some of the lacunas in the sectoral regulations, whether it be the telecommunications sector, or the banking, financial services sector, and so on. So in that context, I'd like to first invite Ms. Paratvikanage to give her initial remarks on this intersection and what kind of elements should the representative of the banking sector should look at in the advent of the PDPA.
Well, thank you. And before I start on that, I want to thank the Chamber of Commerce for inviting the Central Bank, and I'm honored to be part of this workshop today. Actually, Sandhya, I have done a few slides. Would you want me to go through them now? Or yeah, I'll just share my screen. I hope my screen is shared now. Yeah, all right. I just did a few slides to take you through on PDPA and how it affects the banking sector. As we know that PDPA is going to be operational in 18 months and time goes really fast. So there's a lot to be done. And my idea today is to explore the ways in which it would have, like, I'm not saying gaps, but then we would be looking at what we have so far in the banking system and what we could actually gain from the act and implement. So just to tell you the context in which the banking system is, the banking business is full of secrecy. It's one of the areas in which secrecy requirements are like paramount, and it had come into law very early. Now, if you look at the law that we are governed by at the central bank, the Monetary Law Act, which was enacted in 1950, has a secrecy clause under Section 45. And the Banking Act, which was enacted in 1988, contains Section 77, again on secrecy. Section 45 of the Monetary Law Act is interesting because what it says is that except in the performance of our duties under the Monetary Law Act, we are bound by secrecy in all aspects of data that we receive. And central bank is like repository of data. We collect a lot of data from the system for regulatory and supervisory purposes. And because of that, we have a lot of information with us, and we process that information, that data into information, and it is a requirement under the law that we do not communicate that information to anyone except to the monetary board, which is the governing body of the central bank, and also to another officer of the bank, if we are authorized, if that person is authorized by the governor. So there is a strict regime of secrecy at the central bank. And it goes on to say that even courts cannot compel us to give that information, because it says that no officer or servant of the central bank shall be required to produce in any court a book or a document. So like whatever we have, we will not be compellable to divulge any information to courts, except that it is necessary for performance of activities under the Monetary Law Act. So it's a very strict clause drafted in 1950 by John Exeter. So that's where it is coming from to the industry. And when it comes to the industry clause, Section 77, I wouldn't go into all aspects of it, but it gives exceptions, like unless you're called upon by a court of law, or the person, the data owner is requesting you to divulge it. So something like consent, like request to divulge it, or to comply with the law, you may, or in the performance of your duties, you may divulge the information. If not, there is a strict secrecy regime, and anyone who is joining a bank is required to sign a declaration of secrecy, a pledge, like pledging that there would be strict secrecy undertaken by him in all aspects of his job at the bank. And the only thing that the law has provided for is that unless there is a, if there is a requirement to share by customary banking practices, so like a bank to bank, when a customer is introduced, yes, you can give information, but that is only within the customary banking practice. So these are the ones which will be impacted by the PDPA, and we would have to further look into the consent requirement and so on and so forth. When it comes to the latest available laws on secrecy and privacy and data management, it is the regulatory framework on technology risk management and resilience for licensed banks that I would be focusing more today. It has been issued in 2021, so it's just issued last year in December. So it's a very new direction. It provides a comprehensive framework, and it speaks of governance structures and oversight structures. So it's for banks to undertake their work within a compliance structure, mitigating the technological risk that would arise from handling a lot of data. In view of the PDPA, there would be a certain issues like, certain gaps, certain overlaps. As we go on, we can see. So we will see how we can actually address them in a way that it would best serve the people and best serve the public. So we require an information security committee to be established at each bank. That would be the apex body, the highest body that would be dealing with information security risk and technological risk at the bank. It would be headed by the CEO, and they would be responsible for strategic and operational aspects of technological risk and information risk at the bank. Then we also require a bank to have a CISO or the Chief Information Security Officer. He should be a fairly senior officer with experience and also with credentials and with qualifications that would support the role. He should be from seniority level that is not below 2 levels from the CEO. So he's respected and he's able to command work from the other officers and to have a lean workflow. The framework it goes beyond a direction. It tells the bank to do training of the personnel to make them understand and create awareness of the importance of having this data. And then it talks of encryption, what to encrypt and how to encrypt, requirements of having ISO standards and user account management and who would have access to what. So there is a requirement of having a very secure storage systems in the PDPA. So there is like a similar arrangement for banks already in place through these directions. There is a SOC or a Security Operations Center, which is like the forensics of the bank. So if there is any threat to any data, like hacking or any incident at the bank or any data leakage or anything, that is the place that would be monitoring it and would pick it up and would report it. So there is ongoing requirement for vulnerability testing. You would know that every day some data is leaked somewhere in the world. So in all industries are vulnerable to these. So banks especially should ensure that their data is secured and their customers and their information regarding their own bank is secure and not compromised. So vulnerability testing is something that we would require all banks to do. There should be disaster recovery should data be compromised or damaged. And also we talk about where this information should be housed, the location of information systems, the ownership and the management. So that is like a very quick overview of the framework. I don't want to bore you with all the technical details, but I just want to tell you that we do have a system in place for banks already under the Banking Act, which speaks of like having data protection, data collection, processing and collection, and how to secure them. One of the biggest changes that I see in PDPA as an individual, I'm talking just as an individual from the central bank, not the bank's voice, but then for me, it's the consent. The consent, like the PDPA speaks of how consent should be granted and upon receiving consent, what can be done to data. So what are the ways in which consent should be requested and obtained. One of the things that I have noticed regarding banking documentation is that they are very complex. And sometimes we do write things in a way that no one actually understands or the customer is finding it difficult to comprehend. And it makes it worse if we actually draft it in very simple English language and then translate it to Sinhala and Tamil, which the translation is really difficult to understand. So I think this is an opportunity for all the bankers to look at the documentation, especially pertaining to consent, and see whether the person reading it is able to comprehend and understand it properly and knows what they're consenting for. Even in the framework, there is a consent requirement where we say if you're actually sharing the data with a third-party service provider, there is a requirement to obtain customers' consent. But yes, the framework doesn't go on to details about how to get that consent, what are the wordings that are used, what are the requirements. So PDPA is a really good fit for that particular requirement because it is wonderfully spelled out as to what is required to obtain consent. So yes, that would be an area that we can improve as bankers. Data protection obligations, I just picked it up from the PDPA, and those obligations are there. I am told by somebody that there were sessions previously where the act was dissected, so I don't want to go into those details. But I just want to say that those obligations were at heart even at the central bank when we drafted our directions. These directions have been drafted in the absence of PDPA. So there you would be able to, if you actually go through our directions, you might say, okay, this area is not addressed or this is not. But you would also find more stringent requirements than that of that is encapsulated in PDPA. And sometimes there would be like a gap, like this, like where the central bank would require a higher standard. And in that situation, I would personally think that Section 40 would help us, because Section 40 of the PDPA says that sometimes an exemption can be given in the interest of financial system stability, because as the regulator, under the Montreal Act, one of our key, where we do have obligations, and one of our key ones is that we must actually preserve financial system stability. So in the interest of the financial system, maybe we can have strict requirements on banks. Definitely it is up for negotiations, and once when the authority is established, I'm sure we can make amends and have discussions. So yeah, that's my intro into it. So let me see how to unshare it. Oops, Sandhani, I'm stuck with this. Okay, stop sharing. That's right.
Okay.
Sorry about that.
No worries. Thank you, Ms. Abadi. That was a very comprehensive and concise at the same time overview of the kind of interaction that the PDPA has over the existing framework under, particularly in terms of banking sector. So I would come back to you with some of the follow-ups I had during your presentation. And so I'd like to move on to Dr. Vikramanayaka right now, and try to pick your thoughts on what's the intersection you do see when it comes to the non-banking sector, especially for finance businesses, and what are your initial thoughts on the matter?
As I said earlier on, speaking after Bhavitri, especially when my topic, the difference between my topic and hers is actually the sector. She speaks on banking and I speak on the finance business sector. I feel like somebody having to bat after Kohli because she's already scored before I got there. So I actually tried to make it a more, I anticipated what she would cover, and in fairness to her, she shared with me her areas that she expected to cover during her presentation. And I tried to deal with other aspects of this. So what I'm going to do is I'm going to look at the more practical side of the impact of the existing provisions that apply to the finance business sector and compare it with the requirements that you'd be expected to comply with under the Personal Data Protection Act. Yeah, so as you all know, the Data Protection Act sets out the general law on personal data protection, and it seeks to protect personal rights of data, personal data of data subjects. And as you all know, the application of the law is such that it will clearly apply to final licensed finance companies. So there is no doubt about that. The data protection law itself makes it explicitly clear that its provisions will override those of any other written law relating to the protection of personal data of personal data. Okay, so the sector-specific provisions will therefore have to be observed in conjunction with the provisions of the Personal Data Protection Act. There are no two words about it. What does the Act cover? You've been through this in a previous session. What it covers are the fundamental principles relating to how the overall objectives of the Act have to be met. What are they? They broadly cover the use of data, the maintenance of integrity and confidentiality of that data, accountability in the processing of data, rights of data subjects, and the regulation of controllers and processors of data in a nutshell. The reason that I'm going through that is so that we have some sort of context when you look at the sector-specific laws. What is the sector-specific law that we are looking at in the context of licensed finance companies? In January 2022, the central bank issued a direction, number 1 of 2022, titled Technology Risk Management and Resilience. And that was under the provisions of the Finance Business Act. In many respects, they actually reflect the provisions of the direction that Pavitri spoke about, which was issued under the Banking Act. So I will not go too much into detail on that. The overall purpose of the direction was to provide for minimum regulatory requirements on technology risk management and resilience of licensed financial companies. Essentially, it requires boards of licensed finance companies to formulate information technology and cybersecurity strategies that are aligned with the potential risks based on its technology business strategy and minimum regulatory requirements. Now, that's important. The evaluation in terms of the direction must take into consideration potential IT and cyber risks also arising from the use of cloud services and fintech. Also another important aspect to it, which I will deal with later on. So the requirements of the direction are such, as in the case of the Act, that they cannot be complied with or adopted from an off-the-shelf approach or a shrink-wrapped solution. But that is very, very important, right? The attitude today seems to be that people can wait until other people develop the policies and copy it. Right now, that is something that I picked up talking to people in the industry. And that is where they're seriously going wrong. Okay, if you look at the direction itself, it very clearly states that boards of LFCs are required to develop written board-approved policies, ensure sound and robust risk management frameworks, exercise oversight over them, ensure the availability of technical resources and institutional arrangements for building awareness on the subject and to conduct independent audits. Now, none of this can be done by adopting an off-the-shelf solution. Every entity engaged in the finance business and every entity engaged in the same business will have different risks and concerns that they need to be worried about. Okay, and that should be something that should be self-evident to the industry. And it's time that they took note of that. Now, the industry is required to look at the minimum standards set out in the direction, and the boards need to review the level of risk in individual cases. And they necessarily need to up the ante, okay, if they deem it necessary. Based, again, I'm quoting from the direction, based on what they consider to be the commensurate level of risk and complexity of the technologies used. No two businesses will generally use the same technology, nor will their levels of exposure or levels of exposure to risk be the same. In effect, the policies have to be tailor-made and be set down in written form. Now that, you must remember, will come back to haunt you later on when or if problems arise. So you got to give specific thought to those policies when they are being formulated. I won't go into the specific principles that are contained in the direction because Pavitri has dealt with it in broad terms, and a rainy afternoon like today is not the time to go into dreary principles which are very, very technical. But in very broad strokes, they relate to the fair and ethical use of customer data, information classification and labeling, user access management, data encryption, customer treatment, data loss prevention and information security incident response and recovery, vulnerability assessments, information security training, awareness certification, and disaster recovery, all of which are arguably key requirements for the observance of obligations under the Act. Okay, you got to interpret it in broad terms. All of these principles in the direction can be taken up under the obligations under the Act. Consequently, what happens is the provisions of the Act and the direction are not mutually exclusive. Okay, the effect of the direction is really to flesh out the general principles in the Act, and in my opinion, they actually dovetail into each other. Okay, so I look at it slightly differently from how we saw it as. I don't think there is a conflict. They really supplement each other, right? Because even under the Act, there is no standard requirement. Each entity is required to assess the level of risk that they have and formulate policies. So what the direction does is to supplement those requirements. And that's the only way that you possibly can interpret it. So then we come to the question of what the impact of the Act is on the regulatory framework related to the finance business sector. That is the main theme of my presentation, or the area that was allocated to me for this afternoon. I'll deal with it briefly. Firstly, I think it goes without saying that the Act now results in casting obligations which are actually legally sanctionable with more meaningful punishment. Before the Act was formulated, violations of the directions would have been dealt with under the Finance Business Act and been subject to, I believe, at the very most, ₹1 million fine. Whereas now, under the Personal Data Protection Act, the sanctions are far more severe. Second, I think it's also important to note that with the passage of the Data Protection Act and the reading of the direction, boards have been cast with a much heavier responsibility. And I will tell you why. As I said earlier on, the Act sets out the guiding principles and obligations on data protection. These principles must be adhered to based on the relevance and applicability to each entity, whereas the direction serves to highlight sector-specific risks expressed at the minimum, which therefore necessarily have to be addressed by licensed finance companies. Okay, so you're really now, your attention has now been drawn to sector-specific risks at a minimum. Okay. The second point that's important is that the responsibilities under the direction are not limited to the LFC. Boards of LFCs are now specifically required to ensure compliance on an ongoing basis, not only by themselves, but also by agents, third-party vendors, and partners. And it specifies how is generally through means such as service level agreements. Okay, there is more detail in the direction, which I will not go into detail on at this time. The next thing that comes to mind, or the next thing that really strikes you, is that the direction and the Act read in combination result in boards being expected to have a very comprehensive knowledge, not only in the finance business itself, but also in matters such as, again, but not limited to, technology. And when I say technology, it's technology plus cybersecurity risks, and their partners. And in the world of fintech, this includes numerous service delivery partners, okay, outsourcing contractors and the like. So now these are there in black and white, casting a very much higher responsibility on members of boards of LFCs. I'd like to highlight two additional thoughts at this point. The first is you have to remember that in the world of fintech, which is necessary for the finance sector, financial institutions are now compelled to forge partnerships and relationships with third parties who are very smart in ideas, but have very little experience, knowledge, or even concern with regulatory responsibilities and resources. Okay, so that has to be factored in to policies that are formulated by boards of licensed finance companies. Secondly, you have to remember that as far as fintech in particular is concerned, they deal with cutting-edge technology. This will require boards of financial institutions to ensure that they're equipped to monitor and comply, not merely on a static basis, but continuously with their obligations. And that requires you to have and acquire knowledge of constantly evolving developments in regulation, in business and technology. Merely saying that we have complied with the standard in the direction will not do. Right now, this is something that is absolutely necessary for directors and financial institutions to remember. Okay, and in that aspect, the direction is very, very useful in my mind. Now, I'm going to leave you with those thoughts, but before I conclude, because it's an awareness program, I'm going to leave you with some general words of compliance that I like to use in other contexts and which I have used in other seminars on this subject. You have to understand the philosophical underpinnings, okay, to data protection laws. I think that's absolutely important. Even now, a lot of people that I talk to question the need for these laws. So you have to question yourself on what the purpose of this law is. What are we expected to protect and how are we expected to achieve it? And then come up with answers for those subjects. These are going to be subjective judgments that are peculiar to your businesses and your business model. For instance, who is the controller? Who is the processor under your structure? They're not easy questions to answer. Okay, and they're not standard answers either. You have to make these decisions and interpret them on a case-by-case basis. Once you understand your responsibilities, you need to formulate, again, a requirement under the direction, a robust framework for implementing and compliance. Okay, so you can't tick off boxes or apply a string-based solution. It's also, I emphasize, it's not a one-time solution, but a continuing journey that you will require to which will require you to constantly evaluate your industry, your partners, the relevance of your particular categories of data, the changing technology, and above all, the constantly evolving threats, and then reevaluate and recalibrate your compliance mechanisms. So again, this is a message I give everywhere I speak on this subject. It's not an area that can be complied with a mere knowledge of law or of technology. It's a comprehensive, complex, multidisciplinary challenge. Okay, and in that sense, the direction actually helps you, because when you read it, it actually highlights some of the threats which don't necessarily show up when you read the act itself. So this, as I said, it supplements the provisions of the law. Okay, we can go into the costs of non-compliance. That's another interesting area to be discussed. Okay, but I'm going to leave you with those thoughts for the moment.
Thank you, Dr. Vikramanayaka. That was very, I think, very comprehensive explanation and introduction to the directive, especially insofar as it applies to finance business sector. And so just going back to Ms. Vithanage on your presentation. So I mean, both this, your initial remarks, you mentioned the specific information security guidelines that have been issued for both the banking sector as well as the finance business sector. And one of the things that kind of struck me when I was going through it was that, you know, the notion of consent is kind of built into both of these directives rather. And sometimes there's a provision which says, you know, there's you can use data. I mean, the bankers or, you know, finance business sectors can use data as long as, you know, the customers could reasonably expect the purposes of this particular, you know, the use of that data. So there's this very, what I realized was a very subjective test as to determining what the users might reasonably expect at the point they tender their data to a bank or a, you know, financial institution. And how would you see this being, you know, tackled by the industry? Especially sometimes there's this notion among the industry is that, you know, if you rely on consent, that should be sufficient. You know, you detail this very lengthy consent form in legalese, or, you know, it's sometimes very difficult to understand, but, you know, they're like, okay, we have it already on record. And there's a tendency sometimes, we've seen it happening elsewhere around the globe, that, you know, using this consent as a license by these controllers to process personal data to purposes which the user may never have anticipated or they would have guessed in their entire lifetime. I mean, we are looking, not just looking at very tech-savvy customers, but, you know, people from different walks of life. So how would you anticipate this notion of consent to be embedded into this, you know, when you execute the directive as well? And, you know, how would you assess the reasonable expectations of the customers from a consent point of view?
Thanks, Sandhani, for the question. And actually, I'm going to pick on that word reasonable, because in law, there is this concept of reasonably prudent person. Where does that person exist? Nowhere. So it's like, it's very difficult, like, you know, just gauge as to what a reasonably prudent person or what an average person would understand from the, like, of the concept of consent, and also when we write and tell something, whether they would really understand. Because when it comes to banking consent, it comes at the very beginning, like the consent forms. It comes at the very beginning. And if you have ever dealt with a bank or ever dealt with a financial institutions, and if you are in a dire need to, like, do that particular activity with the bank, it would be the banking officer saying, sign here, sign here, sign here. So it would be like, he'll be turning pages and he'll be just putting your signature wherever. So in that context, consent is a very, like a fleeting, like a concept, because it doesn't really, I mean, no one really reads anything. So I think it's a two-way thing. One, there's a responsibility casted on the bankers. Then there is also, I mean, we can't completely like say that there is no responsibility on the part of the customers, because if you look at Sri Lanka's literacy, we are a highly literate country. But if we are literate, if we can read, right, where is the analysis? Can we actually understand what we read? Can we understand what we write? So I think the responsibility also, there's always responsibility on the customers as well to understand. The banks can actually, I'm not saying that banks shouldn't do anything. Actually, banks should definitely simplify their documentation, make sure that the customer understands, and also give some time, perhaps this is just an idea, maybe some downtime for the customer to read the documentation and return to the bank, because sometimes they do it over the counter and the customer is in such a hurry, would agree to everything and later on dispute. So, like, to see how it can be built into these agreements, and especially consent, to give examples as to how this information would be processed. But there are certain laws like the Financial Transactions Reporting Act where information is non-negotiable, like it would be released. So customers would have to understand that there are certain legal requirements where we would collect information and would be releasing that information with or without consent, or mostly without consent, because consent is a non-requirement in those areas. But in other general way areas, whether the customer's information would be processed, would be shared with a third party. So all that is actually addressed in the directions as well. But I understand that there is a need for simplifying the communication. Plus, I would also stress that there is a need for customer to also understand it and make an effort to read the documentation and understand what that person is agreeing to. So yeah, that would be.
And
You mentioned it, but you also got to understand the relationship. You know, it's an uneven relationship. Whether you're financially literate or not, the fact is when you walk into a bank, right, you are, from the minute that you walk into the bank, you know, you feel, you know, that you're getting a favor from the bank. And you would never even think of asking for the documentation to read it or to get the bank officer to explain it to you. Right. So in my opinion, this is something that will evolve over time. I think what will happen is people will challenge documentation, challenge use of this, and say you didn't get proper consent. Right. And that happens in other cases. Even in the courts, you find people signing agreements and saying, I never signed it, this was never explained. So I think it will take time for people to really understand what informed consent is. Right. And it's not something peculiar to a financial institution. It also applies to doctors, to lawyers, to everybody else. You give consent because you have to give consent. If you don't give your consent, you don't get your loan or you don't get your treatment. So I think that's going to be a very, very long process that will come, you know, with challenge, with awareness, and that's the way it will work. I mean, I'll give you a very simple example. In the morning, you hear these advertisements of finance companies, and at the end of things, there's a thing that, you know, blabs something that you can't understand. Now they're giving a warning which is required by the central bank, which nobody can hear and nobody can understand. So people have to challenge those things. It takes time.
certainly it's, I mean, of course, certainly it's the case. I mean, after all, the PDPA, I mean, there's a lot of change that we can expect, not just from controller side, as well as data protection, data subjects perspective, as well as to, you know, raising their level of awareness so that, you know, I think enforcement of this act is a two-way process, because it's not just having that very competent authority with teeth, but also, you know, having informed data subjects who can agitate their rights before the authority is also equally important. So moving a little further about in terms of I think both of you briefly touched about the compliance journey banks and financial institutions will have to face in light of the PDPA. So what are the potential challenges that you identify in this regard, and what's the kind of the role the CBESL, the central bank, has as a regulator to support financial institutions in this journey? And the second part of my question would be to Dr. Wickramanayake, but what's the role the legal fraternity can play as advisors to the banking and financial sector to overcome these challenges?
Well, actually, Sandhuni, I personally would think that because the act is just being enacted and it is yet to be operational, it would be kind of difficult to kind of guess as to what challenges would come, because as Dr. Wickramanayake said, I would also like to think that this law kind of fills a lacuna in the system where like each and every law would have about secrecy, but no particular law addressing about all sectors. So I think we would know the challenges when the act is actually operational. And for now, I think the banks will have to, the industry will have to see about like what we discussed about consent and about data leakages, because this law requires data leakages to be informed, and there are very high penalties of like going into like 10 million rupees. And also one of the key things that I noticed is that there is a compensation element for those who are subjected to a data breach, because the breach could happen at the time, at the point of the controller or the processor, but the person whose data is released is the one who's actually disadvantaged. And it's a very nice thing to see that in the law itself, there is a particular clause which deals with compensation for those people. So these things have to be taken into cognizance by the banking sector, because these are new. And so they will be they will not have a gap between the banking direction and the law, but rather they compensate, and they kind of is the holistic framework for data protection. So yeah, I don't see any challenges in the way that there would be friction, but I would think that we have to up the game. The entire industry would have to up their game and be prepared once when it comes to operation. Then these 18 months are there for us to actually see where we need to address it, look at our documentation, look at our systems, processes, our governance models. And if we are having any challenges in a particular area where we are unable to kind of comply, see what we can do, whether we need more knowledge there, whether we need qualified people there. So this is like the transitional period, I would say, like where we can really try to meet the requirements rather than thinking of it as a challenge, to think of it as an opportunity to come up to mark by 18 months. Yeah.
And Sandhani, you want me to answer the second part of your question?
Yes, please.
Well, I don't know whether that's I don't know what lawyers can really do to deal with these challenges on their own. It can't be proactive, right? One is, I don't think lawyers are expected to go behind clients saying we can provide you with various services. It must come from the industry, right? That is obvious. The second thing that the second point that I like to make is that, I've been saying this over and over again. This is not something that can be done solely by lawyers, right? And I think we need to understand that data protection policies have to be multidisciplinary. Okay, so you have a lot of people saying, I'm an expert on this. I don't think anybody's an expert except for a few people who have actually focused on that. There's one gentleman here who is now muted his screen, and then I suppose Santuni or the other, right? But again, lawyers need to bring in multidisciplinary resources when you deal with these issues. You need tech experts, you need industry experts, because it's only by combining a body of knowledge that you'll really be able to do a proper threat assessment. Okay, formulation of the law, formulation of the policy, putting it out in writing is not the difficult part of it. The difficult part is assessing risks, okay, dealing with tech, and then constantly monitoring the thing. The second problem that we have is, that our industry, and this is not special criticism of this industry, we are laid back, right? And this is something that I argued with even Jant earlier on. This should have been a big bang approach. By giving the industry 18 months, right? You're giving them an opportunity to keep pushing the challenge aside. Because regulation in this country is such that people think it will never come. Okay, one fine day they are going to wake up and find that the day of implementation is in a week, and they'll rush around trying to cobble together some sort of policy, and invariably it will be copying somebody else's policy and trying to put it in operation. And that's going to lead to disaster in my mind. So that's why I think awareness programs like this are important. You need to get the message across to the industry of the importance of putting in these policies early, right? And doing it because they are convinced that there's a need for it, not because somebody is pushing you to do it. Okay, I would like some of you all should do a survey, maybe the central bank, to find out how many of these institutions have actually proactively brought in one of these proper policies. I wouldn't think there are very many. And even if you look at again, no personal criticism of anybody. If you look at the boards of a lot of banks, I don't think they have a clue about this subject, especially tech. Right? So you have to create awareness. It's up to the banks to create awareness internally and get people up to speed, right? early without waiting for the last minute. Okay, you have to understand regulation in this country. People believe that it will never come. And that is something that I am picking up, or that I get the feeling of in respect of this particular law. Jayanta, I don't know what you have to say.
I wholeheartedly agree with you, Dr. Gurunak, and I think I might reserve some comments to add during the next half of the session, and maybe I'll respond to them in detail. And I fully agree with the approach as proposed by him in terms of this being a multidisciplinary subject, the need for multiple stakeholders in an institution to come together, not only to formulate the implementation strategy, but continuously monitor it. And in that context, I think a very important perspective Dr. Vikramanayake added today in this session is that you just cannot do a cut and paste job. The risks in your institution may differ from the others based on the technology adopted, as well as the strategy that the financial institution or the bank is planning to implement over a period of time. Basically, many organizations are having a digital strategy, but very often when they map the strategy, they identify the skills gap and the technical staff needed to maintain the products that they onboard, but the risk assessment is often lacking. And it is in that context that I really commend those who did the regulatory framework through this direction. And then this will go as a supplement to the Data Protection Act as well. Thank you.
Thank you, Jayanta, for your intervention. And I think just building on what was just last said about having that kind of a sense of urgency in order to make to comply with the PDPA. I like to revert back to a remark made by Dr. Vikramanayake earlier about the role of the board of directors in these financial institutions. So one of the key factors in actually ensuring the accountability principles, establishing a data protection management framework in any controllers organization is that top management buy-in. I think that's where any kind of a compliance journey can start. So in that context, what are your thoughts as to the leadership the board of directors should give in an organization to make sure that they fall in line with the expectations of the PDPA on a timely manner?
Every one of these policies needs a champion. Okay, boards don't suddenly or proactively go into a boardroom and say we must develop this policy today because they like to do it. It doesn't happen. It doesn't happen to auditing committees. It doesn't happen to other risk management. I mean, you take all these committees that are there, they are there because they've been forced on them. They've been there because the regulator has clamped down on them for not having those provisions. Okay. Take a look at what happens in a company today. They are now preoccupied with all sorts of other problems. Right? It's basically survival. And unfortunately, I would suspect that this is probably on the back burner as a lot of these companies are concerned. So it's important, again, as I said, it's a two-pronged approach. One is creating awareness so that they voluntarily understand the need for this law, not only because of the repercussions of not having one, but also because they must understand the advantages in having a good policy. Now, that is something that I would have liked to have spoken about rather than the technicalities of this. So you have to convince people that they need to put this for their own good. The second thing is, if somebody gets sued, then at that stage, everybody will wake up and realize that you need these policies and put it in place. And I'm not generalizing, right? I deal with a lot of companies that deal with data, right? All these, these fintech kids, right? No matter how many times you tell them you need to have a policy, they don't understand the importance of the policy. So you have to find a way to drill it into their minds that this policy is absolutely necessary. And I suppose it's only for the moment, it's only the authority of the regulator that can do it. So in that sense, sectoral policies, like in the case of the central bank, with the entities that come under them, and they have quite a lot of authority over them, they should insist that these policies be brought in. Pavitri, I would like to actually know how many of these finance companies and banks actually have these policies in place, formal policies.
Well, Dr. Vikramanayaka, the directions have been issued and there is ongoing on-site and off-site supervision on them. I'm afraid I'm from the legal department. I don't have the data with me right now, but I can tell you that when the central bank issues a direction, it is required that the companies do comply, and we have a systematic way in which we monitor that they comply. But as you say, it should not be just a tick box approach, because they can actually adopt that tick box approach. So going into actually assessing their framework against their own systems and policies to see whether they actually copied, pasted it, or whether they actually developed it is a challenge for any regulator, not only for the Central Bank of Sri Lanka, but for anyone. So I think going forward, especially in the light of the PDPA coming into play and now having this data framework, like where we have to kind of really meet the regulatory plus legal requirements in a court of law, I think the companies should now wake up and look at their own policies and see whether they can comply with their own. Because sometimes when you copy and paste, or when you adopt someone else's, you don't have the expertise in-house to meet the stringent requirements you impose upon yourself. So you're struggling to meet your own conditions. So yeah, while I'm not having the data, I'm sure that the regulatory departments, the two supervisory departments, are actually looking into it.
Yeah. Because when you read the directive, right, what actually springs out at you is that it must be a tailor-made policy, which must be done, with your heart, not because you're compelled to do it. So I think it's an interesting document actually. When I saw it, I was intrigued by it. But the industry needs to understand the spirit of it. It's to protect themselves. It's not external regulation. It's actually internal compliance.
I would like to add to that, sir. I should say that in Sri Lanka, I think there is this inherent feeling when we issue a direction that people think that it's kind of like forced upon the industry and that they should fight it, or they should see how minimum they can do to kind of comply with it. But as you said, yes, I mean, looking at the penalties that are going to be imposed under the law, at least that should wake them up, wake everyone up to kind of meet the requirements. Because in comparison to the Banking Act, which talks about 1 million and 3 years, if convicted, we are looking at like 10 million and compensation and so on and so forth, and a lot of penalties. So that should, and also the reputational risk that an industry, in this industry, reputation risk is very, very valuable. If you lose your reputation, then you're like a non-starter from there onwards. So it's important. So I hope the industry would meet the requirements within the next 18 months. And as you said, wouldn't sleep through the next 18 months, but rather work through it, have a systemic plan, have baby steps, which they have to meet running up to 18 months.
I won't go to the extent of extending the compliment of saying that your regulations are not draconian in every sense, but in this particular instance, I think it is. I would
say thank you to that.
I think it's a shared perception, even when it comes to the PDPA, and most of controllers see this as something that is being forced upon, unnecessary burden, and kind of fails to see the bright side of things, or like to say that the benefits that can accrue from being compliant under the PDPA. I think this is something even Dr. Vikramanayaka briefly touched upon, like the kind of benefits, financial, not just financial institutions, but controllers in general can greatly benefit from being compliant with the principles and other obligations. So what are your anything you like to add on this point?
Are you talking about the benefits?
Yes.
No, the benefits actually, I mean, the benefits should be self-evident, right? I think in the previous presentation, I did this, right? This policy allows you to use your data wisely. Okay, and data is key today. right? If I wish I had the presentation with me. If you actually use your data wisely in today's context, right, there are huge financial benefits to it. Okay, I won't go into detail at this stage. But the second thing is you got to understand, and you got to understand the downside of non-compliance. Now, unfortunately, we've had a couple of instances that I know of where there have been data breaches and serious lapses. Fortunately or unfortunately, nothing happened as a result of it. The people who are responsible for it got away scot-free. Now, had the central bank clamped down on them at that stage, that would have made the boards wake up and put in policies now. And it's only an incident like that that will force people to take this policy seriously. That is the sad reality of regulation in this country.
And if I may just add,
Sorry, I would like to actually add to that because sometimes when regulators take action, I would like, this is going on what Dr. Vikramanayake said, sometimes we are unable to actually publish as to what we've done. So it would be that if a breach has occurred, it is likely that the supervisory departments would have given certain warnings or taken certain regulatory measures like requiring the systems and processes to be more like to kind of revise and revisit their systems and processes. And also when it comes to personnel, there would be like when it comes to assessing their fitness and propriety, it may affect them. So there may be a lot of things that would be happening behind closed doors, which may not be made public. So I would like to just add that point.
Thank you. Your point is taken.
And so just building on what was just said, so what are the current redress mechanisms for customers in the event of a data breach right now under the Banking Act and Finance Business Act?
Well, under the if I may just talk about the FCRD, that is, we have a financial consumer relations department. So if a person is aggrieved by any action that had been taken by the bank or a financial institution, they can certainly complain and we would investigate into the complaint. And there is a dedicated department called the Financial Consumer Relations Department. And they would endeavor to first sort the matter out, like to encourage the customer to first go to the relevant bank and see whether any redress can be taken. But in the case of a data breach, I don't think that any redress can be done by them. So it would be up to us. So FCRT would be looking into it and would be like coming up with some kind of a solution with the bank to work with the bank. But I don't see a mechanism which is equal to the PDPA being followed already, because it's a new concept. So PDPA is very valuable when it comes to that, because if there is a data breach, there is a clear way in which the matter can be escalated, and even to courts where it can actually be escalated through the authorities. So that is something new, and definitely something that the bank should be aware of, rather than just having moral suasion. That's going to be like a legal requirement imposed on them.
And just to, I think one of the things I thought it's important to discuss in this very particular forum is also that the PDPA does not provide like a exclusive penalties or exclusive exclusive actions against controllers who violate the PDPA. Because if you look at particularly section 38 with regards to penalties of the PDPA, you see that the imposition of penalties under the PDPA does not preclude a regulatory body from taking any other regulatory measures, which could include things like suspension of licenses or carrying out their business operations. I think it's one of the things that as controllers, bankers, and financial institutions need to be quite mindful of, because they could be subject to regulatory measures, not just from the DPA, but also from the central bank. And that's a very grave situation to be in as a controller.
Yes, absolutely.
And just to steer the conversation a little bit towards some of the nitty-gritties under the PDPA. And at this point, I'd like to invite the audience also to put in their questions in the Q&A or the chat, so we could pose it to the panelists. So until we receive such questions, so one of the important elements in the PDPA is about information security, as well as, and one of the main factors that are linked to it is the accuracy of data. And I see that, when it comes to even there is a correlation when it comes to data breaches as well. Sometimes people could have, the banks could have stored inaccurate data, which could lead to a data breach on the side of consumers, and might even, in addition to that, might even affect the certain kind of analysis they derive from processing, these kind of customer data. So I actually speak from personal experience in this regard, because I personally encountered a situation where my bank, which is a leading private bank, had, entered the email address incorrectly, and it was a valid email address, that the data has unfortunately gone to somebody else. And there was another incident, sometimes users themselves provide incorrect information. And one of the ways I thought this could be rectified was, having this very simple thing called verification of, contact details, phone numbers and email addresses and things like that. And you see that not happening, despite having, this sort of directives and guidance stemming from the regulator. So what kind of emphasis as a regulator do you place on the accuracy of maintaining accuracy of personal data, as well as making sure that the banks and financial institutions have an ongoing obligation to make sure that their data is up to date?
Well, it's a very valid question, Sadhana, because not only from the privacy perspective, but from the financial system security perspective, it is very important that we identify who the customer is, because know your customer or customer due diligence is the core of a banking relationship. So if you have identified your customer wrongly, that means he's no customer of yours. And like in your case, if the email address is wrong, then it's not you. It's someone else. So it is very, very important that they identify the customer. In fact, previously they can go previously there was this numbered accounts where the customer need not be identified. But with the new terrorism and financing and anti-money laundering regime coming into play, we need to identify the customer properly. So number one, from security aspect of the system. Number two, from privacy aspect as well, it's very important that they update their systems. And we encourage the banks to do CDD or customer due diligence periodically, so that they would be sending, you would be getting, they'll be sending you long list of questions where you have to answer, fill up, and then post it. So there's also when you go to the bank, the relationship manager would ask whether any information has changed, but also the customer also has a responsibility that if they are moving to a different location, having a different phone number, to update the bank, because bank obviously doesn't put the spotlight on the customer and follow them, and there is no stalking of the customer required on the part of the bank. So it's both ways. But yes, if the bank has done a mistake, that is very serious, and it is expected that the banks update their CDD and customer information periodically. And if within that time, if any changes take place, it is the customer's onus to go to the bank and give that information to the bank.
And I think one of the issues I've noted in the banking sector, especially from a customer perspective, is that sometimes these CDD reviews or profiling is they generally take place in silos. So with regards to whether it's building a customer risk profile, only they would be aware, use those CDD data. But when it comes to other sectors of the business, like CRM, customer relationship management, sometimes that kind of interaction between from the CRM team to people, the storage of data does not really happen, and that breaking of communications kind of sometimes contribute to duplication of data as well. So in that sense, I think a lot of work needs to be done. I mean, I'm looking at, I suppose the key is not to approach processing personally, not just from a regulatory perspective, but also to make a much better customer experience, as well as strengthening the trust the consumer would place in the financial institution. And I think we have one Okay, a couple of questions on the chat. The question is there a directive by CBSL on financial institutions to follow the PDPA or guidelines?
No, not really, because when a law comes into operation, we do not have there is no need to issue a direction to follow the law. Everyone should follow the law. So there would be, but when it becomes operational, if there are things that we need to address, the supervisory and the regulatory departments would take steps to issue further directions if necessary.
And the other one is the example that I have just mentioned. I suppose it's the one with the incorrect email address. Could it have been dealt under the secrecy provisions of the Banking Act as they are?
Well, my understanding of the question that you raised, Sandhani, was that they have typed in the email address wrong and that it had gone to the wrong person. So
the storage of apparently what was saved on the system was incorrect to begin with. So data entry error basically.
Data entry error. Yeah, it could be. Yes, I think what Shanaka had said. Yeah, it could be a Section 77 scenario where someone has shared the information, but whether it was deliberate, whether there was an intention and all that. And yes, if there had been a complaint filed, yes, we could have looked into whether those elements could be met.
Because intention is irrelevant, no, when it comes to secrecy.
Yes, Dr. Vikramanayake, but then if there is a, like when it comes to giving information to a third party, now this particular email address being typed wrong, the idea is that it is the email address of the customer. It was not intended for a third party. But yes, it is a matter that can be argued both ways. And I would think that there had been a breach. There is no two questions about that. There is a breach. So if it had been brought to the knowledge of the regulator or to the bank compliance division, I'm sure some action would have been taken. And the only section to go for would be Section 77 at the moment.
And it's negligence on the part of the bank anyway. It's not the customer's fault. Anyway, interesting question.
Yes, and Sandhani, I would like to also say that sometimes banks, when they take up the email address, they send you an email where you have to verify and then you respond back. So maybe not all banks. So these are the things that they have to come up with now to prevent.
So I think, I mean, one of the things banks could learn, or the financial institution could learn from each other, you know, that sometimes there are certain practices one can take into account, you know, followed by sometimes foreign banks, for example, who have, you know, subject to the GDPR or international regulations. So you would see that sort of practices coming in kind of those contexts. But often, I mean, there have been issues, even I've received someone else's login details at one point from a state bank because there was just a little error in the name of, you know, in the email address. And I actually called up the bank and said, you know, being a privacy professional I am, so called and said, you know, this is the error and, you know, you need to please file it to record that this is an incorrect email address. So not everyone would bother doing it. So I suppose it's important that, you know, I think one of the things I like to highlight to the audience also is like sometimes it's, you know, it's a bit of using a bit of common sense. So it doesn't necessarily have to be very technical. You don't have to come up with, you know, things like blockchain solutions for custom verifications. But, you know, you can think very simply. That's one thing I also advise to clients also is like, you know, think of it in a very simplistic way so that you can achieve the compliance requirement that is given out in the PDPA. And so then we have one more question from Shanaka. A negligence occasion breach, assuming it could have been dealt under the existing laws and regulations. Why reinvent the wheel?
Sorry, clear. Negligence?
Negligence occasioned the breach. I suppose he's still referring to the example about the email. And assuming it could have been dealt under the existing laws and regulations, why invent the wheel?
I'm sorry, I need a further clarification on the question.
Unfortunately, that's all there is. I suppose, maybe wondering, I think
No, I think we can answer that. See, it's not a reinvention of the wheel. The limitation in the Banking Act is very specific, right? It is on sharing customer information, whereas the data protection provisions are much wider. It actually relates to personal information, use of personal information, with a much wider concept. The Banking Act, correct me if I'm wrong, Pavitri, the Banking Act relates to account details, financial details.
Yes, it deals with three things. It deals with the bank's own data, customers' data, and then the financial data. So it is an entire data universe, but then PDPA, what I say is that it talks of processing. So collecting data and processing, creating information. So it actually is, as you said, it's really much more broader than the Banking Act. Yeah.
I
You
think
can't
Jayanta
use
has
personal data for other purposes, things like chain mail, marketing, that information has value. Banks can't use it. That's the purpose of this, one of the purposes of this law. Misuse of data.
I think Jayanta
can I
has
make-
his
yeah.
hand up. Yeah.
Yeah, no, I just want to make an observation, Sadhuni, based on one of the earlier questions on the possible regulatory intervention by central bank, and Pavitri's response, Pavitri, on the fact that you mentioned the possibility that central bank may consider issuing appropriate directions after the act is brought into operation, right? So in that light, I just want to make an observation, Pavitri, if you don't mind, in the context of what Dr. Vikramanayaka also mentioned. This is a kind of a greenfield subject. We are starting from scratch. And in the next X number of months, in the run-up to the law coming into operation, there is a need for all stakeholders to work collaboratively, including but not limited to the main regulators across the sectors, insurance, banking, capital markets, and other sectors, including telco regulator, to perhaps consider a bit of a proactive approach, so that the banks and financial institutions will take this seriously, rather than look at it from the perspective of operationalizing the act once the act comes into effect. So broadly speaking, I'm looking at a scenario, we all know the background to it. You may remember, Pavitri, we were entrusted with this task by the central bank consequent to a stakeholder discussion chaired by Dr. Kumarasamy years ago. And our ministry was required to do this quickly to get the investor to give comfort to the investor community. So I think it might be useful to send a positive signal. I mean, just a point for you to think about with your management in terms of investor confidence creation and to ensure proactive regulatory intervention through the measures that need to be taken under the PDPA, in view of the fact that in time to come, the new regulator that is sought to be established will need to sit with all of you and work out sectoral guidelines. So we are in a bit of a catch-22 situation. What comes first? Whether the act should come first, and of course, definitely before the act comes in, first we need to have the regulator in place. And when the regulator is in place, they need to get the act, work together with the other regulators to develop sectoral guidelines in partnership with industry bodies and professional units. Now, all this is going to take time. And if Sri Lanka is to take advantage of the law, and we are the first South Asian country to do so. And if we are to get the advantage of an early starter, I think it's imperative that all stakeholders, including the regulators, work together proactively to find a way where the interventions are done early, so that boards and other institutions will get their act together in a timely and effective manner, so that we send the right signals to the investment community. That's a thought I thought I should rest with both of you. Thank you.
Thank you, Mr. Fernando. I think that's a very valid point. And I'm sure when the regulator is there, when the authority is there, it will be like really smoother. But then, as you said, it's a catch-22 actually, which comes first. So I would take this message across to the management. And certainly the idea is that we do have a regulatory framework. So whatever that has to be introduced apart from the regulatory framework that we already have in place would have to be like the industry would have to be brought up to speed and be ready to comply immediately when the act becomes operational. So that is something that as the regulator we would be looking at. And I'm sure even some action must be taken by the supervisory departments in that regard once when they're doing the on-site and off-site supervision. So I would take that message across, and I'm sure we would be having a smooth transition from the non-PDA to the PDA operations in the banking sector, because we are already having some regulations. It would be a smooth transition, hopefully.
I think we have little time for one more question. So one of the things that is generally asked from the banking sector is with regards to this cross-border processing provisions that you find in the PDPA, because some of the members in the banking and financial sector argues that there is a data localization requirement imposed by the CBS. So I just like to clear there once and for all. So is there any particular rules or directives that mandate data localization for financial institutions and banks? And how do you perceive, if such rules do exist, how do you perceive such rules and directives to be transformed in light of the PDPA? I think it's a question I'd like to put to both Anagay and Dr. Vikramanayake.
Would Dr. Vikramanayake would
like you go first. You go first.
Okay. Again, we are referring to the regulatory framework on technology risk management and resilience for licensed banks. I think the issue that is being raised is with regard to Regulation 9, where we talk about management, like ownership, management, and localization of data. So there are several categories that we're looking at. If it's like a bank-owned data, and if the management is also by the bank itself, we require the data to be localized. And yeah, if the bank is a bank which is incorporated outside Sri Lanka, then permission is granted to use an off-site or outside Sri Lanka location for data localization. I think that like it goes on to several categories. The idea behind the direction is that when there is a dispute or there is some kind of an event which requires us to have access to the data, the jurisdiction in which this data is being located should be somewhere like we can actually access. Our judiciary should be able to reach out, and our like law enforcement authorities and our regulators should be able to reach out. I think that is the only one of the serious concerns that we would have regarding having data outside where we would not be able to have control over it. But yes, PDA does provide it, and I'm sure when we have more clarity and like when we have further discussions, if there's going to be any changes, the supervisors would be looking at it. But for now, the law stands as it is, and we have given certain we have empowered in certain instances for them to have it outside Sri Lanka. So yes, it is like a half-half thing. If it's fully owned, managed, and managed in Sri Lanka, then it has to be in Sri Lanka. But if it's like a third-party managed system, yes, it can be outside Sri Lanka. So the direction is quite clear. And if a particular bank wants any exception or any clarification, they can reach out to the central bank and they can reach out to the director bank supervision in that regard, and would be help to understand or help to find a solution.
Dr. Vikramanayake?
I told you when I have Kohli in my side, I don't have to bat. Okay, I think Pavitri has answered it very well. She incidentally worked with me a long time ago, and I have the greatest respect for her, so I know whom I'm dealing with. I don't have to say anything.
I was privileged to be an intern at Media Partners 20 years ago. I'm pretty old though.
All right. So I guess I think unfortunately we've kind of run out of time because we need to start the next panel discussion. So I think it was a very fruitful discussion with both of you, Pavitri and Dr. Vikramanayake, and it was I mean quite a learning experience for me as well. And I hope the audience benefited from what was said. And thank you so much again for accepting the invitation and joining us and sharing your thoughts and taking time off your very busy schedules, I'm sure, to discuss these very broad as well as niche elements with regards to the intersection between the PDPA and the regulatory framework when it comes to banks and financial institutions. So thank you, Dr. Vikramanayake and Ms. Thanage for your time and your input. And hopefully we'll see you again next time.
Thank you very much.
So I think we'll move on to the second panel discussion. So I'm joined by Ms. Jan Fernando, who is the General Counsel from the ICT Agency of Sri Lanka, and also the Chair of the Data Protection Drafting Committee. And Ms. Kanchana Bagahavita, who is Senior Assistant Director at the Payment and Settlements Department at the Central Bank of Sri Lanka, and Ms. Cheryl Pal, who is representing, who is a Senior Counsel of Privacy at MasterCard Singapore. So thank you, all three of you, for accepting the invitation and joining this discussion today. So the theme of today's, this particular discussion is the impact of personal data protection regimes in regulating payment services and capital markets. And I look forward to hearing the local and global perspectives from our three eminent panelists. So to start off, I'd like to invite Jayantha to give his initial thoughts on this aspect.
Thank you, Sadhuri, and I also thank the Ceylon Chamber of Commerce for proactively taking steps to build awareness around this subject via online means. And I heard today that they also plan to do a in-house session with physical attendance in due course to build awareness in greater detail with a bit more interaction with stakeholders in the future. Now, basically, in terms of opening remarks, I think what I just want to highlight is that piggybacking on the earlier interventions from both Dr. Vikramanayake as well as Pavitra from Central Bank, we need to understand the multidisciplinary approach needed to be kept in mind in the implementation of the Data Protection Act. The law by itself has been explained in somewhat detail in the earlier sessions, and I believe the intention today is not to go into specific details of the various principles that are spelled out in part one. But I just want to underline some important facets which are needed to be kept in mind by the financial sector and especially banks and non-banking financial institutions when they are planning to implement this act. The law, as articulated in the preamble, talks of this act being formulated to facilitate growth and innovation in the digital economy while protecting a framework to protect the rights of individuals. So we need to understand this act from the perspective of being a policy tool to facilitate economic development, most importantly, the frontiers connected with digital economy. The second policy aspect I wanted to highlight is that the law has been formulated with the objective of improving interoperability amongst personal data protection frameworks, as well as to strengthen cross-border cooperation amongst personal data protection enforcement authorities. Now, the ability or inability for a future regulator in this subject to collaborate effectively cross-border with other enforcement authorities would also depend on how effective the regulator is domestically in its collaboration with the various sectors, especially the banking financial sector, which is regulated by the Central Bank of Sri Lanka. So interaction with the various regulators in our jurisdiction and how effective the DP authority is able to engage domestic regulators would augur well in its interaction across borders with enforcement authorities in the field of data protection across jurisdictions. In the context of cross-border data flows, this becomes a very important facet to keep in mind. Earlier, sometime in the early interventions, it was pointed out that some of the penalties under the provisions of the Data Protection Act could possibly trigger other regulatory interventions, most notably through Section 38, subsection 5, which I want to flag for those interested in regulation in relation to the banking and financial sector. It says very specifically, and I think Saburi, you highlighted this earlier as well, the imposition of a penalty under the Data Protection Act will not preclude a relevant regulatory or statutory body from taking other regulatory measures, including but not limited to the suspension of a controller or processor from carrying on a business or profession, or the cancellation of a license as may be permitted in terms of applicable written law. So what that means is that entities responsible for customer data and those which are processing them needs to be mindful of regulatory interventions, possibly from other regulators permitted by written law, that can accompany a penalty in the event of a potential violation. In that context, it's important to keep in mind that institutions, especially in the financial banking business area, including capital markets, should make best efforts to understand the scope and ambit of the obligations imposed on them when they are brought within the concept of a controller or a processor within the meaning of this act. Now, who is a controller and who is a processor has been defined in Section 56, the interpretation provisions of this act. And the processor is very clearly defined to mean any legal person, public authority, or other entity established under any written law, which would determine public corporation, non-government entity, including a natural person, which together by itself or together with another entity determines the purpose and means of the processing of personal data. So determining the purpose and the means of processing personal data is the criteria to come within the ambit of the definition of a controller. And if you look at banks, financial institutions, in the financial services sector, if you look at the capital market ecosystem, the CBS, the Colombo Stock Exchange is operating the CBS at the moment, the brokers, the market intermediaries, investment bankers, all of them would come within the scope of a controller because they collect our data, they determine the purpose and means of processing that data. Many of them have engaged technical or technology service providers, entered into business partnerships with fintechs, with the prospect of enhancing their business potential. In that light, they have to be mindful that the parties they engage with may potentially become processors or sometimes be deemed joint controllers. And in that context, the regulatory ambit and the provisions of Part 3 would apply to all of them, not to mention the primary obligations stemming from Part 1 and other provisions of the Data Protection Act. Now, taking into consideration some experiences in recent times with the digitization initiatives that took place primarily through the joint initiatives of Colombo Stock Exchange and SEC, that resulted in a very modernized customer onboarding digital solution with a eKYC solution that was plugged with the intervention of the technical team at ICT agency, working in collaboration with the Department of Registration of Persons. In fact, it was ICTA that mooted the idea that led to that entire KYC solution. We need to acknowledge that the work done by the then Chairman De Silva. The whole ecosystem got transformed with the enhancement of the client base. In fact, according to the last count, we have seen over 60,000, little over 65,000 new entrants to the capital market ecosystem. A large number of them under 40. I'm told it's over 82% under 40s who are engaged in the ecosystem. Now, in that whole framework, you see multiple touch points that may potentially be impacted by the Data Protection Act in the future. And I say so in a more positive sense because the Data Protection Act provides the governance framework and the comfort and the trust required by the young consumers of that ecosystem to have the comfort that the data they are sharing through that digital app, which connects to the CDS ecosystem, is properly safeguarded. Now, in that ecosystem, we must remember that there are a number of innovations that can be highlighted. Namely, one of the highlights is that we have the a multiple robotic process automations, firstly, as an interface between the mobile app and the CDS core system. And then there's a second interface, a bot, writing or maybe reading the NIC and the information provided by a customer into the BRP portal to verify whether the NIC details are accurate or not. Now, those are automated processing systems that may result in a potential decision whether to accept the onboarding or not. Now, in the context of the automated decision-making provisions in Section 18 of the Data Protection Act, in future, I'm sure the future regulator will set up guidelines on the framework governing these kinds of activity. In the case of the example I cited, there may not be a decision making because sometimes there is a human side to it. The moment it is rejected, the human intervention comes in to verify whether the rejection is correct or not. In that light, we may see a scenario where individuals may want that decision evaluated in the context of the safeguards available under Section 18 of the Data Protection Act. So in that whole ecosystem, we have account transfers inside the CDS in the capital market domain, both intra and inter account transfers, also carried out with support from robotic process automations, processes built in as part of the whole digitization initiative, where the broker would have access to financial data through the broker portal via the CDS eConnect. Now, in view of the fact that financial data would be protected within the scope of personal data, brokers and other depository participants, namely custodian banks, all of whom act on behalf of clients in the CDS ecosystem, may need to review the overarching contractual frameworks and the governance frameworks. And before this act comes into operation, there will be regulatory compliance checks being done in that regulatory domain. So I'm just giving a kind of a early warning or an early alert to market participants, including depository participants, listed issuers and agents, brokers who are part of the capital market ecosystem, that the Data Protection Act and its provisions, which provides safeguards to customers, will eventually enhance the value proposition in that whole ecosystem. But in order to do so, and in order to create the trust factor that builds confidence in that ecosystem, it is useful for all of these parties to look at the touch points impacting on these transactional activities in the context of the provisions of the Data Protection Act, and see how necessary contractual changes, minor tweaks to technological arrangements need to be done, so that a larger number of customers will have the confidence to join hands in this ecosystem. So with that note, Saluni, I just will end up my opening remarks in this segment of the panel discussion this evening. Thank you.
Thank you, Jayanta, for your initial remarks on how this would impact the capital markets structure, status quo of capital markets. So to steer the conversation towards more payment systems, which is the second part of today's discussion, I'd like to open the floor to Kanchana, who represents the Payment System Department at the Central Bank, as well as my fellow colleague at the Data Protection Law Drafting Committee, to give your initial thoughts on the kind of intersection that you identify in relation to the personal data protection, as well as the framework of the PSD.
Thanks, Sandhani. Am I heard well?
Yes.
So nice to see everyone, the whole team, and I think Dr. Vikramanayaka and Pavitri covered most of what we need to say with regards to the financial sector. I have a presentation that I made. Can I share my screen? Right. Can you see the screen? So the topic that you gave was personal data protection regimes in regulated payment services, local and global perspectives. I will focus more on the local perspectives simply because we also have MasterCard, and I think they can give us more up-to-date practical side to the global perspectives. But I will share some of the discussions we've had with other central bankers in countries where personal data protection laws have already been implemented. So if you take personal data protection laws for payments, as Jayanta pointed out in the early part of the discussion, the central bank did initiate this, and one of the main reasons that we did so was because there was an increase in unregulated entities entering the industry, which is, I think, commonly they are named fintechs. And with that, there was a need to have a better framework to govern and protect personal information, because payments data is financial data and also personal data. So so the third parties are accessing very important and sensitive data. So having a good framework to enable that was very important. So since it was going outside the bounds of the licensed service providers that we had traditionally had, we could no longer rely completely on the bank secrecy clauses and the confidentiality clauses that were there. And I think the use and the value of this act will come in the future as the sectors expand. The positive side of a data protection law is that it allows expansion, it allows the creation of new types of innovations and new services to emerge, because there is a regulatory safeguard as well as a regulatory guidance to come up with new services. So those are the positives that are related to data protection regimes. But in the existing framework as well, the payment regulations, it's highly focused on ensuring the safety of customer information. And so we will have to see how the Data Protection Act and the existing laws will sort of interact and work together as they get implemented. So as I think these aspects were covered early in the presentation as well. So the important point is financial data also covers payment data in its definition. And another point about personal data. Now, it says any personal data regarding the relationship between a financial institution and a data subject, financial status, and credit history. So that's a very, very wide area. Now, there's another side to payments data as well. It's giving out a lot of personal information because it has what we actually spend on. It has behavioral data incorporated in it. So this is why it's a very powerful set of data. And it's not just the amount of money that's sitting in your bank, it is actually what you do, your location, everything can be revealed with your payments data. So that's why it's very important to have a very strong regime protecting your financial data, especially your payments data. So the law as it stands, so under the Payments and Settlement Systems Act, so in addition to the provisions of the Monetary Law Act, the Banking Act, the acts relating to non-bank financial institutions and all other regulated entities, the Payments and Settlement Systems Act also has a confidentiality clause. So we treat everything that we receive as confidential, and we only share with institutions that we are confident that their confidentiality is also agreed, is guaranteed. Now, with regards to payment services, we go into sort of the more subsidiary regulations. Now, if you take credit cards, the customer rights is very specifically stated there. And the issuer, so the issuer is the person that you get your card from. So it could be a bank, it could be a finance company. Now they are responsible for the confidentiality of the customer information. And also they're responsible for how it is used if they are going to connect with any third party. So that they must ensure that the confidentiality aspect is always taken care of. Now, the card issuer shall not reveal any information or contact details relating to customers obtained at the time of opening or issuing the credit card to any other person or organization without obtaining prior consent of the customer. So this goes in line with the Data Protection Act. And the issuer should satisfy themselves based on specific legal advice that the information being sought from third parties will not violate the provisions of the law relating to secrecy in transactions. So this is related to secrecy. So now with the Data Protection Act, there is also the added purpose limitation that comes in to be considered. Now, with regards to third parties being used, the processing, now they can outsource certain functions, but still the onus remains on the card issuer to ensure that these rights are protected. The confidentiality and secrecy is protected. Now, if we go to another place where we have third parties, so the reason I'm focusing on third parties here is if they're a bank or a finance company, they already get they are subject to the secrecy provisions in their specific acts. So we take those, since they're already applicable, we don't need to specify them here. Now, another place where third parties can access payments data is internet payment gateways. So sometimes you might notice there are, you don't go into a bank before going into a bank frame to put in your card details, you might see another entity in between. Now that is the third party that provides the internet payment gateway. Now they're only allowed to transfer the data, but not have the data. So the licensed financial acquirers, and those are banks generally, they're the people who can, so if we go to a shop and if you see a POS machine that you use the card on, and if you have you will see a sticker on it, and it will generally have a name of a bank or a company. So those are acquirers. So even for the internet, they still are the acquirers. So they are the ones who outsource that to third parties. However, so the licensed financial acquirers cannot share sensitive data with the third party. So things like card number, security code, they must be kept with the bank itself. Now, with regards to mobile applications, we introduced a minimum compliance standard in 2020. So this guides the mobile apps, the mobile payment apps, on how they should design and develop their mobile apps. So it's a technical and security standard. And in that, sensitive data is specified, which includes customer credentials, bank account numbers, payment card numbers, and similar fields. And it addresses how to enter and store the data and where the data can be stored. Now, this is very important for the Data Protection Act as well, because storing is part of is captured under processing. So you have to store it under a licensed LFA, an acquirer's domain, because acquirers already have to meet certain security standards. And if not, it has to be a PA. It's a PA DSS or PCI DSS security standard environment. So those are security standards under which card information can be stored. So sensitive data, except card data, shall only be captured in the ecosystem approved and regulated by the CBSL. So as you can see, there as much as possible, there are provisions already to minimize the types of data that any entity has to keep. For instance, sensitive data that can be stored in temporary storages. They have to be erased, and the sensitive data cannot be stored in the mobile device. So, and also there is a specification on how to encrypt the data and provisions for data logs and leakages. So it's quite, at a very technical level, the instructions are already there, and the payment service providers must comply with these guidelines. And even if you take an e-money system like EasyCash or mCash, they are also subject to the same type of confidentiality, and also responsible to ensure that the service providers, that is, if their agents and everyone who has access to the customer's data, because the relationship is with mCash or EasyCash agents, and even they will treat the customer information as confidential. So when we go for oversight and supervision, these are things we check to see what procedures they follow to ensure this confidentiality for all the licensed service providers. Now, when it comes to the interaction with the Personal Data Protection Act, an interesting point that we have to consider is that it has to be specific, explicit, legitimate, adequate, relevant, and proportionate. So we have to see how this can be practically, what the practical consequences will be, given that the payment data has a wide range of information. The existing law is for licensed service providers to hold on to that information and not share it. But if we go into a regime where there is consent-based sharing, then now in Europe, in certain countries, this discussion has begun as to whether you standardize the types of the nature of the information or the details of that information that gets shared, so that no one violates such provisions. So these, I think, practically we will have to see once service providers have the need for such sharing, and then if we need to bring in some regulations to enable that, or whether we can do it under the existing regime itself. So the integrity and the confidentiality of data and the obligations of processors, I think the existing payments related regulations already provide for that. But one key thing that the Data Protection Act does is it will enable further improvements. to make this more comprehensive. And something that's really important, I think, is the role of the data protection officers and the officers in the banks, in the central bank. All of them will have to play a very active role in increasing the awareness and understanding how to come to a practical way of implementing this act, and also seeing how the users, that is the controllers and the processors, can actually benefit from the law. The role of the authority will be very important, and the relationship that the authority has with everyone that comes under its purview, and how the authority guides all the stakeholders and the new controllers and processors will be very, very important. So as the authority will have to have a very active role in building good relationships. And of course, as Pavitri also mentioned, it has the rules that the authority sets will have to be in line with Section 40. And we will see, and really, we really have to see how the implementation will take place, especially in line with the new types of services that will emerge. So some aspects for us to consider as we go forward is there is a lot of obligations on the controllers and the processors, but also in terms of payments, there's a lot of obligations on the customer, because because this act is ultimately to protect customers. But so customers also need to use safe payment methods, safe websites, and secure their personal information. So if the customers are not conscious about the value of their personal data, this becomes very difficult to implement. And from the regulated entities aspect, or any controller or processor, I think privacy by design is something that you need to bring in as soon as possible and try to make it practical. There's, like what we are seeing now, if you go to a lot of European websites, is we have a large data protection related page where customers have to read more than what they would have to read when they go to the actual article they want to see. So which means customers are just going to say okay and move on. So, but also we have to balance it with the obligations and whatever legal implications that the controller and processor would have by not disclosing certain aspects. So that balance, the text and how that is presented, that would be very important to strike that balance so that both sides benefit from the designs and the steps that need to follow for compliance. So cybersecurity is really important. I have not finished that. So in most countries, I think more than non-compliance of the specific data protection laws per se, I think data breach, the chance of a data breach happening is much higher. So really getting your cybersecurity in line is very, very important. And also, as I mentioned earlier, having a close dialogue with the regulator. So it could be the central bank, it could be the SEC, whoever your regulator is, start having that conversation and see how that would work, because then the regulator will also see the practical issues that you might be having, because I know that banks are now working with lawyers to see how to comply with the data protection law. So start having that conversation. That's very important. Don't wait until we come on supervision and then say that there's a problem, or don't wait for the DPA to come to you because there's another authority now. So have that conversation so that the regulator also can help you. With regards to fintechs and anyone, I think this is not only regarding payments, this is for any financial service, and any new entrant to any regulated industry. The most important thing is you must have domain knowledge. Your product depends, the quality of your product depends a lot on your domain knowledge. And domain knowledge is, if you're in payments related domain knowledge. If you're in credit, then credit related domain knowledge. And of course, financial services in general. When you have that, it's much easier to bring yourself in line with other laws, such as the data protection law or AML CFT or any other ancillary law that will come that is connected to the area that you're working in. So gaining as much domain knowledge will help you really make the best of these new laws. So, see the Data Protection Act as an opportunity rather than something that will make life difficult for you. And as so, just stressing on that point. So I think what's really important is regulator can be an enabler if you understand it well. So understanding the opportunities is very important, and understanding the purpose of this law. So the purpose of this law is customer protection, as well as enabling innovation through interoperability, wider international connectivity. So make use of that possibilities that have been given while safeguarding the customer as well. So that, I think, is all I have. Thank you.
Thank you, Tanshana, for that very comprehensive description and taking us through the aspects of the PDPA as well as the existing framework for payment and settlements in Sri Lanka. So I'd like to come back to some of the points that was mentioned in your presentation, but before that, I'd like to move on to Cheryl, who is the Senior Counsel, Privacy and Data Protection at MasterCard. So I think the only non-regulator participant of this panel today. So I'd like to hear your thoughts on, the kind of experience you have encountered when complying with, global and regional data protection regimes, and the kind of experience that you'd like to share with the audience.
Thanks, Andani, and thank you so much also to the Ceylon, Chamber of Commerce for organizing an event like this. I think it goes without saying, and I think all the panelists that were in the previous panel discussion as well as here, right? I think the one common theme is that we need to create awareness. People need to be aware of what is happening, what are the new laws, what are our compliance requirements. It's important not just from the perspective of those who need to comply with it, but also those to whom these rights belong, right? Our consumers. So it's important for us to be conducting as many of these awareness sessions as we possibly can, just so that we can all sort of finally be at a more level playing field, so to speak, right? So again, I think you sort of hit the nail on the head, Sandhani, when you said that as the only non-regulator panelist today, and I take that up as an absolute privilege to sort of probably bring some perspective from the other side of the line, right? The guys who actually have to go ahead and implement the regulations. So honestly, I think before, and I do have some slides prepared, so I will share my screen. But even before we go into that, I do want to call out that the Sri Lankan PDPA and the process that we've been through, right? The journey that we've been through in trying to get the act to where it is, the sort of feedback that we've been able to give to the draftsmen and the receptive sort of attitude that we've seen has been very, very encouraging. If only all regulators and all draftsmen across the globe were as receptive, right? It would make life much, much simpler for us lawyers trying to implement them. So definitely want to definitely make a mention of that. All right. So what I wanted to sort of quickly talk about today, before we start sort of our Q&A, is to see why do we even need to bother with privacy compliance, right? Why even think about privacy so much? Why place so much importance on privacy, right? I think the knee-jerk reaction that most companies have is to say, hey, it's the law. We don't have a choice. We have to comply with the law. And because if we don't follow the law, of course, there are penalties, there are fines, there are, you like I think Sandhini, you had mentioned, you could possibly face suspension and all of that stuff. But let's take it a step beyond, what are the immediate legal, implications of not having in place a privacy compliance framework, right? And I just want to sort of throw up some statistics for everyone to sort of just sort of, I guess, absorb, right? And these stats have been pulled up from the 2022 Cost of a Data Breach report that is annually released by IBM Security and the Ponemon Institute. If our audience members have not read that report, I very strongly urge them to read it, because it really does put things in perspective, right? So 83% of organizations who were studied for this report have clearly said that they've had more than one data breach, right? 60% of those organizations actually said that the immediate consequence of this data breach is an increase in prices, which have to then be passed on to the customers. Now, as a part of this study, they've basically put together what the average cost of a single data breach in 2022 could be. And the number that they've actually come up with studying all of these organizations is $4.35 million US. Again, we're not talking about a few 100,000. We're not talking about the simple fines. The actual cost of a data breach is, on an average, $4.3 million US, right? So it's not something that we can just use a checkbox sort of a method to say, hey, we have this consent in place. Hey, we have a privacy compliance framework in place. We have to be more proactive, and we have to take privacy seriously, not just because it's the law, not just because it could cost you, but because it's the right thing to do. We are ultimately servicing consumers. We're trying to build the economy, and it's important for us to take the right steps in a positive manner to sort of move to a better world, really, right? So privacy, because it's the right thing to do. Now, I think we've had sessions before where we've spoken about what are the exact requirements under the new PDPA. We've, of course, heard from our panelists about what the intent of the regulator is. In my experience, all of this is information that's obviously very helpful. It's useful, but most companies, more so the smaller companies which can't afford, like a tier 1 law firm to be helping them out, or doesn't have a very large, let's say, legal team in place to break this down. They're usually like deers caught in the headlight, trying to figure out where to start, right? So what my next few slides are just sort of, I guess, to give everyone, our audience here, a very high level understanding of what we need to do to move towards compliance with what our privacy requirements are, right? The first step of which is figure out what you have in place today. Do a self-assessment, do that self-audit. Try and figure out what is the data that you hold, what is the data that you process, where are you getting this from, what are you using this data for, right? I think we've heard this time and time again in today's sessions. This is a multidisciplinary exercise. This is not something that your legal team can just sit for 2 weeks and sort of try and figure out on their own. They will need to get their business folks involved. They will need to get their commercial lawyers involved. They need to get their tech involved, right? You need to figure out what are your processes, what are your systems, where is the data coming from, where is it going, how long are you storing it for, what are the access controls that you have in place, right? This is because we're again talking about primarily financial data. it's of course supposed to be treated with that extra care and caution, right? Another very, very critical thing which we now have to think about now that we have the PDPA in place is to try and figure out what is our role. Are we a data controller? Are we a data processor? Yes, there are obligations on both sides of that spectrum. Yes, those obligations are overlapping to a great extent, but they also have independent sort of existences which you need to think about, right? If you're a processor, you need to think about not just your processor roles and obligations. You need to also think about what your controller may be requiring you to do for them to be in compliance, right? So it's very important to, as step one, try and figure out what data you have, where it's going. Essentially, if you are actually a part of a global organization, a lot of this would have come up with the Schrems II judgment that came out in the past couple of years. You would have started doing your data mapping exercises, and I think that's a fantastic first step, right? So think about that, get started on this. Now, once you've done your self-assessment, then comes, I would say, the second toughest part, right? That's reconciling any conflicting obligations. This is, I guess, to a great extent relevant for global companies, including someone like a MasterCard, which has operations in multiple countries, right? Where even if you don't have directly conflicting obligations, you could have different obligations. In certain jurisdictions, for example, you could have the need to respond to a data subject request within 15 days, whereas some others would have 45 days, right? So what do you do as a company? Do you say, hey, I'm going to take the strictest sort of threshold and say that this is what I'm going to apply across the board? Do you instead say, hey, no, we can't do that because that doesn't work for us, and we have to actually put in place country-specific, sort of processes to deal with it? So what I would recommend is that you try and reconcile these conflicting obligations, because we also have regulators who are like Ms. Kanchana just mentioned, right? They're willing to be enablers of business. They're willing to also hear from the industry as to what is confusing, what is it that we're facing a difficulty with. Take complete and total and full advantage of that. Get clarifications, try and drill down on exactly what it is that you need to be implementing as a company, as an entity that is regulated by, or that is required to comply with the PDPA, right? Simple things like, must a DPO be appointed? The answer is yes. Now, does that DPO need to be a single DPO for, let's say, 3 group companies within Sri Lanka? Do you need to have separate DPOs? These are questions that will come up once you actually start delving into each of these compliance obligations, right? How do we really go about building our breach notifications? Do we need to, as processors, inform our controllers? Do we have an obligation to inform the regulators? Do we have an obligation to inform our data subjects, right? So think about these sort of compliance requirements which are applicable to your industry, to your company, to what it is, the specific processing activities that you undertake, and drill down on all of these. Because ultimately, and the reason this is very important is because once, more like it, until you have clarity on what is it that you are expected as a company to do, it's going to be near to impossible for you to flow this down to all your other teams who need to actually practically implement it. So you need to, as I'm guessing a lot of our participants now are actually one way or the other legal, or probably our cybersecurity colleagues. So you need to drill down on these so you can actually spread that out across the organization. Right. So I guess the third step is creating a privacy compliance framework or a privacy compliance program, right? I cannot stress this enough. The first and most important thing you need to do is make sure that you have senior management buy-in, right? This is not a check the box. This is not just one other form that needs to be filed, or one other submission that needs to be made. It is important, it is critical, and it is here, right? This is not something that's, I don't know, 10, 20 years in the future. We are here right at that juncture where we need to build that compliance in today, lest we actually have to deal with the 4.35 million that we spoke about, right? So make sure that you sort of communicate to the management about just how critical it is for us to build this program, right? And privacy compliance is not just limited to, okay, how are we collecting data? What are we doing with it and where it's being stored? It also includes things like responding to data subject requests, responding to government data requests, right? I think there was a question on localization in the previous session, and Pavitri sort of mentioned it very, very clearly. The idea of any localization is typically to try and figure out how, or to try and enable quick movement of data to the government when it's necessary, right? So have a process in place, have a protocol in place, and how you're going to deal with it, so as to be seen as enablers, to be seen as partners, right? Not just someone who's blocking this, but someone who's actually working with the government for the greater good, so to speak. Have a data incident response plan in place, right? In your privacy compliance policies, framework, program, whatever it is that you want to call it, because ideally you would have had the clarity that we spoke about in the previous slide, you will be able to actually put this together in a easy to understand form, make it easy to read, try to avoid legalese. As lawyers, it comes to us very, very naturally to make it seem like only lawyers are going to read this. So my advice is always try and make it as simple as possible, such that your business folks can read this policy, right? They should be able to try and figure out what is it that we mean when we say privacy compliance. It goes much above just exactly what is written in the letter of the law. You have to be that bridge to try and convert what is written in the letter of law to what we can do practically as an organization, right? So some of these examples are on your slide. What processing activities are an absolute no-go? For example, if you do not want to be, let's say, looking at face recognition, right? If you as an organization have said that, hey, we are not going to collect something like that, or we're not going to collect geolocation, right? And these are organizational decisions. Make that clear in your policy so that your business understands that. What are the minimum requirements for consent? Some of your teams may not be able to really understand what you mean when you say specific, legitimate, explicit consent, the difference between explicit and implicit consent, right? Things like this are what gives lawyers a lot of sort of job security, if I may say so, because our job is spent trying to translate this for our business. But honestly, think about that, try and put together simple, clear statements which are easy to understand. Explain the privacy principles with examples is what I would always sort of advise you to do. And I think it's very good for us to use the sort of the carrot and the stick method. Always sort of make it clear that, hey, the reason we're insisting on this is because this is what happens if we fail, right? We have, and I'm sure everyone who's here on the panel, or even our participants will agree, we have seen a definite increase in enforcement, in sort of attention for all things privacy, right, across the globe. We are seeing more and more sort of smaller countries where we didn't think that we would be seeing a privacy law for years to come, actually taking up that mantle. And as a business, I think it's also about changing mindset to say that, hey, if we have laws, if we have clear laws, that comes with a lot of certainty. And when you have certainty as a business, that is fantastic, because then you know what you're getting into. Then you know what are the four walls within which you can operate, right? So also just sort of, I think of it not so much as a compliance burden, but as an opportunity, like all our panelists have been saying before us. Right. Okay. Now it's very, very tempting for everyone to jump up and say, hey, I have this new amazing tool which helps make compliance easier. It's completely automated. Your entire privacy program will be automated, end to end. And that is fantastic. That is great. I think it is absolutely great that we do have these tools, which makes compliance so much easier now. Simple example, right? Previously, I think if you had data subject requests that would come in, you would need to manually go through, let's say, your logs, your files to try and pull out information about that one particular person. Now you have tools which automate this process, right? So the minute I, as a consumer, go in and say, hey, I want to know all the data you hold on me, it's that much simpler because the tool already pulls up that report and helps you provide that. So I think tools are great. I think it is amazing to see the kind of automation that we do have in place for enabling compliance. But this is not a sort of a one size fits all solution. It is not a panacea for all our privacy concerns. If only things were that simple, that we just subscribe to a tool and everything gets done. It's not that easy. It is very, very, very critical for all of us to review and our use of these tools, see if it needs to be updated, and make sure that we have tools that work for us, right? And tools that actually help us comply and not just increase our compliance burden. The other thing that I will definitely speak about now is investing time, patience, and effort in compliance training. It is not enough if your legal team knows what privacy compliance is. It is not enough if your cybersecurity team knows what they need to do to make sure that data is secure. It is something that has to be dispersed sort of throughout the organization. You have to be able to build it or absorb it into the culture of the organization. Now, something like this takes time, it takes effort, and it takes patience. It's not something that's achievable overnight. You cannot expect everyone in your organization to wake up tomorrow morning and be able to sort of tell you the definition of what personal data is. It's not going to happen. But if they're able to wake up tomorrow and be like, hey, there is this thing called personal data, which we should be a little careful of because we do have compliance obligations, that's a win, right? So it's important to invest that time in training, in making the organization itself understand what it is that we mean when we say privacy, what is it that we mean when we say security, and how we are responsible for these things, right? So that's on tools. I think this is my last slide, right? So it basically, everything that we've spoken about, I think, ties into this, right? Privacy by design. It is a word that is used and abused, but I can't say it enough, right? It enables us and to sort of embed privacy within everything that we do, keeping in mind your consumers, their interests, right? It is something that is critical, that is crucial, and that's not going to go away, right? Now, what do we do after we've sort of put together our privacy program? We've sort of trained people. Now what, right? That's when you come up with your accountability framework, right? You have to be able to demonstrate compliance with your privacy principles, with whatever your privacy program is. And for that, you need to think about how you're going to really implement that. How are you going to monitor it? How are you going to evaluate whether you're actually following your privacy principles, right? What are the controls that you've put in place and how effective is it, right? Of course, DPIAs are an important part of accountability. When you're talking about sensitive data, when your law requires you to specifically conduct a DPIA, make sure that you do it. Don't scrimp on these details. Really do it, not just, again, as a check the box, right? But in order for you to show that you do take privacy seriously and that you are doing this, keeping in mind the fact that you're trying to keep the interests of your consumers at heart, right? And I think I just want to conclude with just to say that, you will never fully achieve 100% of a privacy compliance. No one can give you 100% sort of a clean sheet of paper to say that your job now as compliance officer is done, right? It is always going to be an ongoing event. It's going to be a journey. The only thing you can do is constantly update yourself, constantly audit yourself, just to make sure that you're on top of things, right? And this is it. This is all I just wanted to take some time and share. So over to you, Sandhini.
Thank you, Cheryl. And I think I owe a great deal of gratitude to MasterCard country manager Sandhini for actually suggesting you as a speaker for this panel. And I think it's been a very rewarding 20 minutes for the audience as well. So, and thank you, Cheryl, for that very comprehensive analysis of what are the expectations, kind of things that the controllers should be mindful of. And I think it is very useful to give that indication or to give that basic guideline so that they something for them to build up on and read up further. So I'd like to I just have a few questions for the panelists, just to follow up on what was said. And just to, I'll like to start with Cheryl, actually, about the, and also Kanchana for that matter. You mentioned the privacy by design concept being embedded into the operations, the data producing operations. And actually, we were quite fortunate to have Dr. Anne Cavolk here at the very first workshop we had, and who spoke exclusively on this very principle. So I think one of the misnomers that there is when it comes to compliance under the PDPA is that there is this notion that, you cannot achieve privacy or data protection concurrently with your other obligations. Like there is this notion of, it's like a zero sum or positive sum approach. So the idea is that, it should not be a trade-off between privacy as well as compliance, but it's something that could be achieved concurrently. So in light of that line of argument, one of the things I like to hear your thoughts is on this increasing use of biometrics, especially in the payment services and financial transactions for the reasons of convenience, security, and authentication. So, generally you have various types of apps or, different applications which relies on the use of biometrics for authentication purposes. So could it be stated that the increased reliance on biometrics is actually in favor of strengthening the privacy requirements, or strengthening? If I go a step further and say, does it really embeds privacy by design in that sort of application? So is it in contrast, or does it go really beyond the controller's obligation towards purpose limitation, data minimization, and so on?
Thanks, Sandhini. I'll take a crack at that, at answering that question first. So I think to deal with the second part of your question, right, does it go beyond just, let's say, the core privacy principles? And I think we are at a stage, not just in Sri Lanka, right, globally, where I think companies, regulators, everyone has understood that we do need to step up and go over and above just those core principles, right? So whether it is specifically about biometric data, whether it is about use of AI, it goes much, much beyond just those core principles. There is also sort of the expectation that anything that we do is done ethically, right? And specifically in terms of biometrics, I think it's a fantastic example of how privacy by design can actually be implemented in a way that benefits everyone, that benefits the business, because it becomes easier for them to reach out to many more people. And a simple example, right, because we are talking about payments, is in countries where we may not have a high literacy rate, right? So people may not be able to necessarily always sign off on something. They may not always be capable of getting an OTP. They may not even have mobile phones. So forget about smartphones, right? They may not even have mobile phones for us to try and authenticate the customer. What do you do then? They may not even have something like a a government provided ID, or sometimes they do have it. So what do you do in such a situation? How do we know that the person standing at my, let's say, shop counter and trying to sort of withdraw money because of whatever, amazing innovative solutions we have, how do I know that this person is actually Cheryl and it's not someone else, right? So I think biometrics is a great game changer in that way. At the same time, it does impose that extra obligation because it is that much more sensitive and sort of susceptible, or makes that data set very vulnerable to misuse, to data breaches, and all of that. So I think, yes, for sure, it imposes a higher obligation, and rightly so, right? But this doesn't mean that we can't do this in a business efficient and like a privacy compliant way. I think they both can be sort of melded together such that it works for the benefit of everyone.
Thank you, Cheryl. Any thoughts, Kanchan, if I pick your brains on the matter?
Yeah, I think Cheryl really covered that. And I think whatever the data that you use, biometrics or any other data for authentication, I think the basic principles of ensuring that they're safe and storing them in a manner that it's encrypted and people can't hack into it. I think those principles apply regardless of whether they're biometric or any other information that is there for authentication. And it's continuing to keep reminding yourself of that obligation, that you shouldn't sort of be lax when it comes to storing any of that data. And also in the points of processing, if you're going to use a third party for some point of processing of that authentication data that you have stored, then you have to be very careful about who the third party that you're joining with, and make sure that you have the necessary agreements, the safeguards, so that you are safe. And when you are safe, the customer is safe. Because in financial services, that's the principle. You safeguard the institution so that the money of the customer is safeguarded. So the same applies to the data as well. So the entity, the institution, the controllers, the processors, if they follow those safeguards, then they will be safeguarded, and in turn the customer's information will get safeguarded as well.
Thank you, Kanchan. And I think I would agree with what Cheryl said about reaching those levels of financial inclusiveness in our society, especially in the grassroots levels. And you see that happening, especially in disbursement of subsidies by, government or non-governmental organizations. And it kind of, there's two sides certainly to the story, and about use of biometrics, and should not be discouraged at the very face of it. But everyone can agree that it imposes a certain high degree of responsibility on the part of the controller as well, in order to safeguard this very sensitive data categorized as biometrics. So with that, I'd like to move to Janta about, this. You mentioned in your presentation as well about use of automated processing and automated decision making. So in something that is close in line with that is customer profiling. So it kind of plays a primary role in today's financial transactions. So how is this sort of activities are balanced against the rights established in the PDPA? Particularly with regards to automated decision making, and which includes profiling of customers.
Yeah, so it's a very interesting issue, Sadhuni, and I think if we remember at the time of the drafting of the bill, even formulating the language around automated decision making and scoping that provision was a challenge because of the evolution of this subject in number of international institutions in more mature countries. The subject was being closely reviewed and been subject to continuous change and adaptation, especially in Europe, Canada, Japan, and a number of other countries. However, we thought it fit to adopt some degree of compromise and formulate a provision with, I think, in my opinion, is slightly narrower than some other countries, where it is hinged on a possibility to review a decision. So if we can distinguish a decision-making process from a mere automation process, I'm sure a controller or a processor will be able to distinguish between the two and determine the applicability of the law or non-applicability of the law, right? That is one aspect I want to highlight very specifically. And we all know that when we look at Section 18, for example, the provisions are very clear that in time to come, the Data Protection Authority will be specifying criteria regarding the measures a controller would be required to comply in the context of an automated decision-making scenario. At this moment in time, the Data Protection Authority is not yet established. And of course, as I said in a number of fora, we will not be able to predict how the new regulator will behave. However, we believe with the appropriate expertise, the criteria that a controller should comply with in giving options for review in an ADM scenario will be determined at a later date. But in the context of profiling, basically based on the examples I gave in a current live scenario, it is noteworthy that the Data Protection Act also very clearly, in terms of application of the Act, provides for a framework where the circumstances relating to profiling with the intention of decision making of data subjects, there will be rules formulated by the new Data Protection Authority in future. Having said that, Sandhini, I just want to add to a point relating to the question you asked just before you came to me on the biometrics side of data and processing thereof. It is worthy to take note that controllers who are engaged in processing these types of data will have to abide by the criteria for processing of quote unquote special categories of data. And it is important to draw your reference to the conditions in Schedule 2 of the Data Protection Act, which gives the conditions that can be fulfilled for processing of biometric, genetic, health, and other related data. So if you're having biometric-based authentication platforms and systems like that, we need to be mindful of lawful processing permitted within the framework of Schedule 2, taking note of the fact that any one of the conditions being satisfied is sufficient to bring it within the scope of lawful processing of special categories of data in compliance with Section 5 of the Data Protection Act. Thank you.
Okay. Thanks, Jayant. I think that kind of relates to one of the questions raised on the chat as well. I think you'd be the best person to answer this. The question is, when will the authority, I think it's the Data Protection Authority, be established? Are you in a position to give any indication as to when the authority would be set up and what the kind of, if I may just add on to that question, what the kind of timeline controllers can look at?
Yeah, so I think I will push that to the host of the session, namely Ceylon Chamber. Ceylon Chamber has been playing a pivotal role in building awareness and also leading the advocacy for the establishment of the Data Protection Authority. And maybe, of course, Central Bank, SEC, and other regulators would have a stake in the establishment of the new regulator, because this cuts across a number of sectors and also government, digital health, and number of programs. The scope and ambit of the regulator is significantly wide, but there is an interplay between the new proposed regulator and the other regulators. So as noted by Kanchana, as noted by Pavitra before that, as noted by many of the speakers like Dr. Vikramanayaka, there is an interplay that is required between all of the other regulators and these new regulators as the oversight body for digitization of all sectors. And the impact of digitization is going to be subject matter of the new data protection regulator. So in terms of timelines, I don't have a date with me at present, but I know there are discussions going on with regard to the approach, and I'm sure Ceylon Chamber in time to come will play a significant role in that, and they can keep us informed about the appropriate timelines. But I just want to add one last point on that note, namely that in the context of the central bank directives dated 9th December 2021, and the subsequent one referred to by Dr. Vikramanayaka, dated somewhere in January 2022, which applies, I believe, to the licensed finance business organizations. The factor to keep in mind is that these new directives would play a pivotal role in setting the tone. And I just want to emphasize that in the absence of a data protection regulator, these two directives from central bank would play a pivotal role in setting the tone and the stage and enlightening boards and other and senior management of regulated institutions the need to put in place the compliance risk management framework, and the guiding instrument comes from these two directives. And as noted by one of the speakers, this would be an important supplement to potential new regulations, guidelines that would come in under the data protection regulatory framework. And both the Data Protection Act and these directives can supplement each other to nourish and create an ecosystem of a trust environment for users to have confidence to use digital solutions in the future? Thank you.
And I think the response also bodes into the next question raised in the chat as well. So the question, I like to put it to all three panelists, like the question is, it's not practical enough to have organizations internal policy on the PDPA without guidance of an authority or guidelines by a regulator, because once the data protection authorities formed, the controllers will have to redo the policy, and it would have an adverse impact on the company's time as well as cost. So I like to hear the thoughts, your sentiments on this particular observation made by one of our members of the audience. What are your thoughts on the matter?
So maybe I will let Kanchana and Cheryl go first, and then I will add my perspective.
Yeah, so I think that's a very important question that many people have, because we have to understand the reality, which is there is always a cost involved when there is a new regulation that comes in. But what I think that needs to be understood is most of the principles in the Data Protection Act are not sort of very outlandish or anything. They are the principles that are being followed internationally. So we can already see a lot of the financial institutions. So even if you take sort of a credit card, hotel deal, SMS, they have incorporated certain aspects, like you can stop the subscription, they disclose who it is, they cover a lot of the information already required. So I think you have to slowly bring it into your systems, and there will be certain specifics that will come once the Data Protection Authority comes in, and sometimes those specifics might not come for a long time. They will look at the market practice, how the market is adopting, what are the issues that are looked at. Generally, a regulator does not start from day one issuing directions and circulars. They will look at what the market, how the market is responding, especially because some period has been given for the market to now take action. So that's very important. So you have to slowly start building that into your system. And if there will always be new directions and new rules coming in as technologies change, as the market needs change. So you will never have a completely closed situation. So even though we have one of 2020 and one of, I think it was one of 2022, I'm not sure about the number, the two directions and all the directions that we issue with, if there is some change required, we will, those directions will also change. Now, for instance, if I take the mobile compliance guideline, the first was in 2018, and in 2020 we revised it, because we understood how the market was responding, and then we changed it. So looking at how the market behaves, that will, the rules and the directions will change. However, the requirements of an act will still be there for a much longer time. So adjusting your company's information infrastructure system rules to embrace those principles from now on will make your life much easier when the time actually comes to conform to specifics. And as Jayanta mentioned, this authority will look at a lot of the existing practices that are in place. So it won't sort of just suddenly ask all the companies to do something that no one has ever done. So you have it will be taking a very practical approach. So keeping that in mind is very important, that you start incorporating those practices step by step, because you can't do everything at once. You can't suddenly comply if the regulator issues something with, let's say, a short deadline, then you can't suddenly comply overnight. So you have to keep those things in mind. Yeah.
That's a very valid observation, Kanchana. And sharing any.
Yeah, just very quickly, I think Kanchana has covered most of everything that, I mean, the appropriate response to this question. Just a very quick thing, right? Agility. You need to be agile. That's the name of the game. You need to be able to respond to new requirements quickly. You need to be, which is why you need to develop a program which can be updated, that can be adopted, that can be changed as per new, more prescriptive provisions or directions that may come in, right? And that's I think our role as in-house legal, or, to make sure that our policies are drafted in such a manner that we can, as and when we have more specific directions, update it, review it, and like Kanchana had mentioned, it's an ongoing process. It can never be a completed sort of policy that you would have. It's always going to be something that's subject to updating, that's subject to new requirements that come in.
Sure. If I thoughts, Jen?
Yeah, so I think I just want to, while agreeing with what Kanchana and Cheryl said, I just want to emphasize a point made by Dr. Vikramanayaka at the outset, and many of the previous speaker, and I think Cheryl articulated this very effectively in her presentation today. In fact, we need to acknowledge the fantastic presentation she made along with Kanchana as well as Pavitra. One thing to be kept in mind, as pointed by many speakers, is the multiple angles the regulatory aspects in this area needs to be looked at from. And in that light, even sectoral guidelines or just merely waiting for those guidelines to come in to guide internal policy development measures may not necessarily help an organization reap the benefits of this data protection regime. If one were to look at the regime holistically, we need to keep in mind that despite options available to data protection penalties, some countries have taken a criminal sanctions-based regime, which I would call a hard law. Some countries have taken, and some jurisdictions and economic zones have taken very strong measures based on percentage of total revenue, as we see in Europe, impacting the business and growth potential of organizations in those jurisdictions. Whereas in our part of the world, we have taken a softer approach, where the penalty regime is preceded by the options for directives and course corrections. So there are possibilities of intervention at various stages, including appeals to various higher fora. So it is an administrative law framework that has been put in place to create the confidence for end users whilst imposing a governance obligation. So rather than wait until guidelines and other rules are formulated, the minimum standards are set forth already. And based on what Dr. Vikramanayaka and others mentioned, one can evaluate your exposure and the risk based on the strategy in your organization and the technological measures already being used to implement and provide business solutions to end customers. But if you look at this from opportunities perspective, I think if you look at the data protection law, you might see, as pointed out by even Kanchana, number of options for growth and new innovations for technology companies to partner with financial sector organizations to add value to digitization and the digital transformation process in our country. And I think we should look at it from that perspective, and rather than wait for guidelines to be formulated, look at processes, improving them, improving governance, adding technological aspects, engaging in partnerships to drive business opportunities, resulting in better growth potential for organizations in the future. So I think if you look at it from that perspective, we may be better off than looking at it from a narrower angle of waiting until guidelines are formulated to formulate your internal policies. Thank you.
And I think I would fully agree with your thoughts, Ajahn, because and this kind of brings ropes in a view expressed by Dr. Vikramanayake as well about, this whole exercise is an ongoing exercise, and I think this is something that we, Cheryl as well as Kanchana reiterated over and over again. And I think it's important that controllers look at data protection management framework, not just the policy, as a living and breathing, continuously evolving policy, or like a framework within any organization. So it will, just like Kanchana pointed out, I mean, technology changes, and it's important that, the laws will change to keep pace with the changing dynamics of the technology space. So therefore, any organizations cannot be stuck with a policy or a framework that was designed to fit the legal framework that could become soon obsolete, especially in this highly technologically driven digital intrinsic sector. So I think with that, unfortunately, it's all the time we have for this evening. And I'd like to thank Jayanta, Kanchana, and Cheryl for taking time off. They're very busy and hectic schedules to share your thoughts and experiences in this area of the intersection between the personal data protection laws and the payment services, as well as capital markets from a local and global perspective. And I thank the audience for their questions and for staying with us for 3 hours almost. And so thank you again for all our panelists for this evening. And I'm grateful for Ceylon Chamber of Commerce also for facilitating this sort of discussion. And I think more to come in this regard as well. So with that, thank you so much, and wish everyone a very pleasant evening.
Thank you.
Thank you. Thanks for having me.
Thanks for the feedback as well. So thank you, everyone. Thanks.
Thank you. Thank you.